We have a lot of ground to cover today, so just a couple of questions. What's the most common speed made at? Not guilty, that's right. Just remember, the vast majority of cases are resolved eventually by plea bargaining, 6 to 7 out of 10, in most jurisdictions, some jurisdictions higher. But at the beginning stages of the process, when we're just getting started, bring it in, when we're just getting started, it's going to be a plea to not guilty, and that's when the defense then takes over, putting pressure on the prosecutor, at least raising aspects that may be strengthen their legal position. So not guilty at the arraignment stage. After arrest, within how many days must the suspect be arraigned to not violate the right? Be arraigned. All right, so it'd be 30 from arrest to arraignment, then 10 from arraignment to indictment, and then from arrest to trial, it's a total of 100 days. All right. So in order to not violate one's Sixth Amendment right to speedy trial, right, from the time you're arrested, you should be brought to trial within 100 days. As we talked about, the police often give up that right. It's much more advantageous to wait. The longer they wait, the more it helps their case, that helps their position, so they would waive that right. But they could, in fact, try to get to trial within 100 days. Last question. In Seattle, the decision is formally charged is made up of grand jury made of 30 individuals. This is, we talked about 23, and many states, many counties use 23-person grand jury. That is not constitutionally required. The jurisdiction can decide any amount. They can decide 100-person grand jury, they can 1,000-person, 15-person, smaller. So whatever that is, in Seattle it's 30. A grand jury refuses to issue an indictment in a robbery case, which means what? How many people said there's not enough evidence to indict? Majority. Okay. Grand jury, all it is the majority of the vote. So all you have to do is one more than half. So in here, it's 16 people said we don't think there's enough evidence to indict. That doesn't mean the person's off free. All it means is that at this particular point in time, there's not enough evidence to charge. The prosecution go back to the police and say, go get more evidence. They go get more evidence, they go with another grand jury. And all that additional evidence, the jury, grand jury can come back and say, again, there's still not enough evidence to prosecute. Keep going back and back and back, which would violate anything regarding double jeopardy or anything. Fifth Amendment protections against double jeopardy only come into play once a trial happens and there's a verdict. So eventually, the person, the prosecution, if they feel they can get enough evidence to charge, then. So just remember that a preliminary hearing with the grand jury results in indictment. The other option, which is formally charging a suspect, is a preliminary hearing. Right? A preliminary hearing is different from a grand jury hearing in that it's before a judge, and then the judge makes the decision, and then what is filed is information on the indictment. Okay? Remember, grand juries are secret hearings. That is, you don't have the right to be there. I don't have the right to be there, and members of the public can't go and attend grand jury hearing. The news media doesn't have the right to be there. Right? The defendants can be there, but they don't have to be there. The defendant does not get to present any evidence. The defense attorney does not get to prosecute in a grand jury hearing. Really, for the prosecutor take control of that. At least enough evidence to formally charge. All right, any questions? All right. So, this is our last class about this particular section. So we talked a lot about the rules court structure. We talked about the court work group, and today we're going to talk all about the trial. We spend a lot of time talking about the jury trial as well as the presentation of evidence, as well as some thoughts on eyewitness testimony and how reliable it is. We did just a reminder. Our third test is on Thursday, chapter 7-8. I have to have a review session actually tonight at 8 o'clock. there's a women's policing conference, Wednesday night, Thursday, so I have to be where I want to attend that, but I'm also part of the chaperone. So, I won't be able to do it tonight. At 8 o'clock, I will send a Zoom after class sometime this afternoon. I'll also post that review session slide sometime tonight, so afterwards, so those slides, we'll review those slides. Any questions? On the exam? Study guys out. All right, take a second to read through this case. This is the case we're gonna walk through there. Criminal justice. All right. So this is what happens, right? Officers clearly have enough to establish all the progress and make an arrest. Remember, at the beginning stages, a couple things happen. Right? Importantly, at the initial appearance, at some point within 48 hours of that arrest, Mr. Washburn will appear before a judge. And then he'll be informed of a variety of different things. Informed of assigned counsel and also be informed why he was arrested, and also he will be judge to consider whether or not he should be released pending his trial, and or whether or not he should be detained in jail. Right? If he's released, we talked about a variety of different options in terms of how he might be released, different types of bail, conditions that are posted as part of that release. In this particular case, because Mr. Washburn, we talked about variables that impact judge's decision making. Here you have serious crimes, so the judge might not be inclined to do post bail in this particular case. Also has concerns about whether or not he may be appropriate, right? He doesn't have residential stability. How are you ensure that he's still up subsequent court hearings in this particular case? He may just deny bail and say, you have to be in jail to trial. The informal charge decision happens simultaneous, about the same time as the bail decision, where the prosecutor, right, the initial appearance, the judge makes the primary decision. Informal charge decision, prosecutor. To the prosecutor in this case, this is the case you're going to charge, probably, right? It's a really, really strong case. All right, look at all this list here. Who's the prosecution's witness? Who will the prosecution use as witness in their trial? Good. The wife, obviously, she's the eyewitness. She was part of it. She has that experience. So should we use? She'll probably be the first witness that's put up. A lot of times you want to right there, report with the jury, right? So to talk about the loss of her husband and what happened on this, and what she saw on that day. Right. Right. Then you jump in, right? He's a really important witness as well, because he's celebrating his eyewitness. Talk about Dave Elizabeth about his ability to be a good witness. That's what he used. Right, Dave, the wife, who else? Good. Who's that? Oh, yes, right. Danny Can as well as Officer fans, and I'll talk about it. Talk about what happened, the impact of it, trauma. So again, he's also an important witness. Who else? remember, every part of the case, right? Every part of what happened has to be established. So actually, everybody on here is probably a prosecution witness, including the officer. Both police officers and these officers testified what they asked, how they established probable cause, how they made the arrest, what they saw, how they processed the scene, how they used the scene. Dr. Ford also, we also talked about the extent of the injuries, which he had to do in order to save his life. Not charged with, won't be charged with murder, but probably charged with attempted murder, right? Serious crime. But I had to establish sort of the extent of the injuries and perfect individual. Lori Deanny, I don't think I missed anybody else. I think that's everyone. Now, who testified for the defense?
As soon as the prosecution except the defense is just going to cross-examine them, they might throw David Washburn on there as well.
Yeah, Mr. Washburn, all right. Well, are there other things you can think about? Remember, we talked about defenses and different types of defenses. What might you think about as a defense attorney that you can use? Somebody who's not up here. Go ahead.
Like a character witness from Washburn.
Yeah, all right, you can bring a character witness. The fact that he's a war veteran as well as homeless, right? Whether or not, some reason, post-traumatic stress or something, in terms of giving some, remember, defenses aren't, not necessarily I didn't do it, but I did it, but there may be some reason why I did it. So all of that, you have to call some expert about the blood evidence, using the blood evidence, using the physical evidence. We'll also call up somebody if there's any question about the quality of the blood evidence that's used, right? Mr. Washburn is certainly, you can put Mr. Washburn on the stand. Most people say don't, right? The defendant shouldn't take the stand. They're not good at it. Should exercise their privilege, not being eliminated themselves. So, again, that case will walk through this process where the prosecutor really charged they have really strong evidence against the crime that probably detained his trial in a particular case. Depending on the jurisdiction, there has to be a formal charge decision which happens after the prosecution makes their informal decision, whether it's a grand jury. Remember, it's just a majority vote. So if there's 60 people there, you have to convince 31 people to indict Mr. Washburn. Or a preliminary hearing which occurs before a judge. Once that indictment happens and or the information happens, we get to the arraignment where again, is informed of his charges as well, but also the important thing, this is where he's asked to enter a plea, and as we talked about at the beginning class, so enter a not guilty plea at the beginning stage is more than likely. You could also make a guilty plea, a no contest plea, which is exactly the same thing as a guilty plea, except it's not an admittance of guilt. We talked about why that might occur, but also it could be insanity. Rare, but we could. And then we ended class last week about motion. All right, this is once he's formally charged, his defense attorney will think about ways to sort of whittle away, break down the prosecutor's case. So perhaps a Fourth Amendment issue with the gathering of the night might be an issue. Maybe some, might be some other things in terms of discovery. There might be a motion to continue the case, whatever it is. And then eventually, if he doesn't plead guilty, we get to the trial. I'll talk about that. So remember, most people at some point before they go to trial, they give up their rights, their constitutional right to trial, and they plead guilty. Talk about why that is, all the benefits of pleading guilty. You're hoping to reduce your sentence and the amount of punishment. In general, at this point in the process, prosecutors typically have a pretty strong case, right? There's a lot of filtering that goes out earlier in the system. Police officers not making arrests. Prosecutors not charging them, don't have enough evidence. So by the time we get to the latter stages of the court process, the prosecutor feels like they're going to win because they have a real strong case. Doesn't mean they always win, but it's usually in the defendant's best interest to change the case, not guilty. But if they don't, that's when things get real exciting. Then they gotta try. Defendants have the right to choose either a jury trial and or a bench trial. A bench trial is simple, it's before a judge. So the judge hears all the facts and the judge ultimately decides the verdict. All right, so a bench trial, that's all it is. But then the judge instead of jury makes the decision. Jury trial, obviously, we spent a lot of time talking about it. Members of the community are brought in to hear the facts that pertain to the prosecution side of the story, hear the defense side of the story, and then issue a verdict. All right. So the defendant can choose whether or not they can have the case before a judge and or a jury. With the bench trial, they're relatively rare, but there's some advantages, some reasons why a defendant might choose a bench trial over a jury trial. One of those reasons is if you get a lot of publicity in a particular case. We talked about pretrial publicity and the impact of potential jury members, right? The judge wouldn't be likely to be as influenced by that publicity as the community. So if the defense tries to move a case to another jurisdiction or are unsuccessful, they're not able to do anything to get raised some concerns about that publicity, the defendant may choose to have a trial in front of the judge rather than a jury. Another reason is that it's a complicated defense. Oftentimes with financial crimes are extraordinary complex cases to prove. They're all extraordinary cases to defend as well. Oftentimes, it's a lot of science, it's a lot of math, it's a lot of other issues. And so sometimes defense attorneys feel that the jury may not grasp the scope of the defense because it's such a complex defense. Instead, they'd rather prefer to try the case in front of the judge rather than the jury. They're hopeful that the judge will be able to grasp the sophistication of the defense, the highly technical defense, so the judge might hear the case. The last reason, the third reason why a defendant may choose a bench trial is because the jury may be unsympathetic to the defendant. Right? The defendant will be present in court sometimes because of just their appearance, because of what they did, multiple child sexual counts. They're called on trial for sexually abusing children, right? Some defense attorneys might argue for a judge. They're hopeful to be much more neutral and impartial, whereas members of the public, they see, they feel for those children and they have been sometimes ruling just on the evidence without emotion. All right, so that's the first decision the defendant gets to make. We're going to talk about the jury trial. So you'll have to know for Thursday, it's important to know the number of jury members that we use as well as the process. How do we get an actual jury? It looks something like this. So the short of it is that, remember, a jury is supposed to be a composition of the community where that person is. So people, in theory, are randomly selected from the community and asked to serve as a jury. So let's just say Mr. Washburn, this particular case is a trial, a serious trial, a violent crime trial, right? And he's requested for a trial. If you get here, so what the clerk of court does then is identify those two communities as you get a letter, and some of you probably have, that you will be called juries. Usually it's for a week long period, sometimes some communities 2 week periods, some communities 4 week periods. But you get a notice in the mail saying you've been called to jury. Right? That doesn't mean you're going to serve on it. It just means that you're one of the eligible individuals that may serve on the jury. Now, there's reasons, and oftentimes people try to get out of jury. You might say if you're not from this particular area, California or Illinois, and you get a jury summons to appear, you contact the court, get the class, that's final exam, in a couple of weeks. I can't come back for a jury, and you'll have either your service postponed or they put you back into the court to get it out of the next time. And so what happens then is that we have to decide how do we pick people in the community to get to what is called the jury. Now, most places, right, use something along the lines of voter registration. So if you're registered to vote, people will be randomly selected from those voter registration rolls and then asked to show up. So they'll be part of the jury. Right? The jury pool is in there, it's usually about anywhere from 50 to 100 individuals, depending how complicated the case is. All right? And so 50 people in the community will be picked, and then the two attorneys, prosecuting attorney and defense attorney, will select from that group of 50 to 100 people to get to our jury. Juries are oftentimes 12 person. That's kind of the public conception of what a jury is, a 12-person jury. But that is not constitutionally required. Many jurisdictions use 6-person juries in their trial. Right? 6 is the minimum number. You have to have at least 6 jury members for your trial, and the maximum number is 12. Usually a 6-person jury is 12. That was a lot, so let me go through it. So the first step in selecting a jury is going from the community to the veneer. I mean, if you imagine, if we had to select a jury from just the people in our class, right, that's our CJ 110 community. You can think about a number of ways. You can pick from the people who are here today. I can randomly pick 12 people and say, okay, you're the jury in this particular case. All right. What's the problem with that? Supposed to represent our class. I just randomly pointed 12 people and said, okay, you're the jury. What's the problem? It may not be a representative sample of our community. Remember, there's people who aren't here, right? And the question is whether or not people who aren't here are different than people who are here, right? There's another way that I can select it, right? I have a list of my class list, and everybody I can just randomly pick 12 names from that list, send a notice that you're the jury, and then you're supposed to show up. Well, that's the same thing that a community makes. How do we get a representative list of people to serve on the jury, right? Most people use political roles for people who are registered to vote. Again, what's the problem? How many people are registered to vote? Many of you, most of you, great. Not all of you, right? We also know that some people aren't registered to vote, right? Obviously, people who are not registered to vote are different than people who are registered to vote. Right? Whether or not that's representative. So that's the most typical way to do it. There's really not other good options. When we used to have telephone books, we used to use telephone books. Everybody used to have a landline. Some places would essentially use telephone books and select what people who live in the community. Since now, most people don't have landlines, it's very difficult to get that. Political role is the number one way to get there's nothing. All you gotta do is show up. All right. There's, I mean, this is where we get at background checks, kind of. This is how you start weeding people out. But as long as you're registered to vote, right, legally registered to vote, you're one of the, the people who be asked. Doesn't mean you'll actually do it. All right. So going from jury to veneer is think about the veneer as a jury pool. Okay. that is getting to a number, a large enough number, so that you can select people to actually sit. So, again, very cool, very nice. Maybe it's only tied to, but it could be. So, notice that here, go out. So we did one of the very cool jury process here to get through the Now we have to really prove it, and we are all of them, right? We have to get all of them, you can show us. I mean, so. Other questions? Go ahead. Uh, The defense attorney can say whether or not they're representative of their peers or not, right? And so there's a lot of case law on establishing whether or not they met, especially on race grounds and other grounds, because oftentimes prosecutors will systematically eliminate people either through for cause or use all their peremptory challenges against the defendant is black, every black potential jury member up at the thing. They're not allowed to do that. But they used to do it all the time. They have a feeling that they're not going to be, they're not going to get, not be as prosecutor friendly as perhaps somebody else. And so they would use all their peremptory challenges based on a particular race. They used to do that, though, because they take that, they can't do that sometimes. But they can propose whether or not these is a group of people that represent it. All right. Problem with jury process. Some of our obvious, one of the problems we already talked about is that the jury community, where we get to the veneer is bias. It's actually biased for conviction. So going from community to veneer, that process is biased for conviction because who's most likely to not be on voter rolls? People who are lower SES. There's also race bias and who's on the election roll. And so already there is some bias in terms of who gets on juries and who don't. Who doesn't. That's one problem. The second problem is that people lie when they're voir dire. It's like a job. But with voir dire, people either really want to get on a jury or really don't want to get on. Okay? Most jury trials last 6 to 7 days. Could you imagine if the jury trial, you got called a jury service and you didn't have to serve, right? So the next 6 days, the next 6 weekdays, you have to show up at 8 o'clock in the morning, sit through a trial all day, and at 5 o'clock you get to go home. That means you miss your class, so you this with anything else, like, how many of you can do that, right? And keep up with your work and everything else, right? So people will show up and say, I mean, I can't just work in this situation. That's only if the trial is 6 days. Sometimes trials last 6 months. There's been trials that last a year and a half, right? So if you imagine him doing one of the trials that last a year and a half, in your life will change. You started today, a year and a half, your friends will be graduating, you're like, oh my gosh, I'm still on this dance. There's really internal justice I want to ensure that never got to leave. But, all right, so the jury community, the veneer is biased towards conviction. People lie, they don't speak the truth. Jurors don't pay attention is the third problem. Like a class. You know, we kind of start drifting off, which is the photo that jurors fall asleep in very common. Because, you know, long testimony from scientific testimony is going to bore you. So being able to grasp that, but also before you go to sleep. And the last thing is the juror's ability to comprehend legal complexity. You know, it's up for attorneys to try to convince individuals of their vision of the case, but that's difficult to do. All right. Has anybody ever served on jury? Highlight from my life. About 2 years ago, I was in the public. When I got called, I was in the jury school. I said, there's no way the defense attorney is going to allow me on the jury. But they love it. I mean, whatever you're trying to ask, your day trial. It was fantastic. Give people the business. So don't avoid it. All right. So a couple of real important cases that you have to know. First, in terms of the number of jurors, right? So the number is either going to be 6 or 12. So historically in the U.S., we've used 12-person juries, but that is not constitutionally required. What is constitutionally required is to have at least 6 people sit in the jury. You can't have a jury with 5, or 3, or anything like that. So most communities use either 6-person jury or 12. Most communities use both. It just depends on the jury. Probably serious felonies are going to be heard by 12-person juries. Misdemeanors, if they go to trial, less serious felonies than 6-person juries. But the important case to remember is Williams v. So there is, we do not have a constitutional right to a 12-person jury. As you have a constitutional right to have at least 6-person jury. So then the other area that you think about is whether or not the verdict has to be unanimous. So all federal cases for a very long time have been required to be unanimous, meaning that all 12 people have to agree on a guilty verdict for you to be found. If there's one person that says, I don't think this person is guilty, right? And they keep fighting, and all the other jurors try to convince the person that I don't think this person is not guilty. That jury will come back as a hung jury. If they can't reach the person, it's not unanimous, they can't get the unanimous. The federal cases for a very long time have been unanimous. States have been different. In Oregon, it used to be where all you had to do was convince 10 out of the 12 people in the jury box that this person was guilty. And be found guilty. It's a non-unanimous jury. In Louisiana, they use 9 out of 12. All you have to do is convince 9 out of the 12 people that this person. Right. Both the Supreme Court and both of those states upheld those less than unanimous. 10 out of 12 in Oregon, 9 out of 12. However, recently, in 2020, in Ramos versus Louisiana, the Supreme Court changed its says that in all cases, the jury has to stand. So it goes back to now the federal rule here, was what we did in all states. So if you're brought to trial, in state or federal court, and you go to jury trial, whether it's a 6 or 12 person jury, it has to be unanimous. All members of the jury have to be. Right. That's right. Important distinction, really important distinction between a grand jury and a jury. Right? Grand jury is earlier in the process. It's all it is a majority vote, and all they're really ruling on, is whether or not there's enough evidence to charge or formally charge a person with a crime. Remember that here, what they're ruling on is whether or not they're guilty beyond a reasonable doubt. The standard of proof is beyond a reasonable doubt. So you can imagine getting 12 people in the room and convincing them how difficult it might be to convince all 12 of the person is guilty beyond a reasonable doubt. So it's a very different decision, and it's unanimous in trials. It's unanimous. Other questions? All right, so let's go through the trial process. So remember, one of the things you're going to be asked to do on Thursday is sort of know the steps of the process, the order of the steps. All right. So the first thing we got to do is select a jury. Second thing we have to do, now we have a 12-person jury. All 12 people are seated, and the trial begins. And so this is where we're going to stay. An opening statement is like an introductory paragraph. Okay? What the prosecutor does is gets tries to go forward with 12-person jury and says, "This is my case. This is how I'm going to prove guilty now or that one. I'm going to have 2 police officers talk about how they arrested me. I'm going to have the victim and the victim's spouse testifying to the impact of that victim. I'm going to have an eyewitness. That's all that happened in the report. You have the doctor. All those things sort of just giving you a kind of a roadmap of what we're going to do, what they're going to do. All right? And the prosecution will probably talk about this. The defense attorney is going to present their side of the case. Mr. Washburn, a war veteran, who did their history. They have a put, psychiatrist understands, they talk about the impact of all that. His behavior, you want to think about that. Those lines that they use to the judge, hear the evidence side, and then at the end, decide the impact. So the prosecution goes first, and then the defense gives their opening statement. The defense can choose not to give their opening statement at the beginning of the trial. They can wait. So the prosecution presents their opening statement. The defense attorney says, I defer. I don't want to give my opening statement. They give their opening statement after the prosecution presents their statement. So the prosecutor, remember, the burden of the proof, the burden is on the state. The proof that this person is the crime, so the prosecution gets to go first. And so the prosecution presents all of their evidence, right? And so they call witnesses. They'll call scientific experts, they'll call police officers, they'll call victims, eyewitnesses, they'll put all that evidence in front of the jury, and they'll walk the jury through what happened. All of what they have on a particular day. So what types of evidence do we have? We talk a lot about the collection, Fourth Amendment collection of evidence. That's real evidence. The gun, the weapon used in the crime. blood evidence, real evidence. Fingerprints. So when we talk about real evidence, any evidence that consists of the physical material for traces that were get radiant experts. People who are, presenting DNA evidence, blood evidence, is a scientific expert. If you're presenting tire tracks, right, and saying that this tire track match the car, the defendant in this particular case, then that's what you do, an expert that did the analysis that compared each tire track to the track, the tire track. This is from another case, where the victim was run over by a car. This is actually a test about the insert of the tire fitting into the car. It's a scientific expert testified that these tire tracks match the defendant's car who's the rest of the year driven by. But that's real evidence, right? The evidence that's physical, and then you can really sort of walk us through what that means. The other type of evidence is you present direct evidence. Right? Scientific evidence can be excruciating to hear if you're a member on the jury. We're walking through the scientific analysis in order to get that fact, this DNA match. Direct evidence is really important for the prosecution to get this. Because what this is that it's evidence that proves the fact. And so this is eyewitness testimony, victim testimony, whatever it might be. But this is the storytellers of your case, your prosecution. This is who saw what happened, and they're going to tell the jury what they saw happen. So let me tell you about it. Bank robbery occurred. You all know what a strip mall is, right? In this particular strip mall, there's a number of businesses in the strip mall. There's a bank, a branch office of a bank on one side of the strip mall. There's a number of stores in the bank office on the other side of the strip mall, which is a laundromat. And in the laundromat, this woman named Donna Lee was there doing his laundry. We received a call at the bank at the end of the strip mall that a bank robbery occurred. A 20-year-old teller who was on her second day of the job was at the counter, came, had a gun held to her, and said, "Give me everything, give me the money that you have." She was a bit older, so she had money in the drawer in front of her. She took the money out of the drawer, and she was instructed by the manager, ever there was to be a robbery, to give the money. With all the money, gave it to the individual then walked out and left the bank. Immediately they called the police arrived, they go directly to the teller and said, "Give me a drive." He was robbed. And so he gave a description of the individual, the female, these characteristics. We started hoping that they catch the person close to where it happened. They start driving away, or they leave the parking lot. They see Miss Lee leaving the laundry line. They feel that's the thing. So what police do in those particular circumstances is what they did here. Police officers asked Mrs. Lee to accompany them back to the bank. He said, "Well, I have the clothes in the dryer." They said, "Well, you can go back to the court and come with us." So they take Miss Lee down back to the bank, 20-year-old teller, and they put Miss Lee in front of the bank teller. The 20-year-old says, that's the rob the bank. For that bank run. Charge of bank run. Now, there was some discrepancy between what Miss Lee was wearing that day and what the actual robber had. Miss Lee was wearing a black hat, as you can see. The robber was not wearing a hat at all. Miss Lee was wearing a black leather jacket, which is the picture. But the robber was wearing a dark jacket, but it was more of a trench coat rather than a regular jacket. Miss Lee was wearing a blue blouse, which again, you can't really see because he was wearing no pictures, a white sweater, light blue jeans. The robber was wearing a turtleneck sweater, a gray striped shirt, and also had on faded boots. Bouchard eventually let go because he obviously recognized that the eyewitness testimony was flawed. So, it brings us to a very important on direct evidence that eyewitness evidence. It's absolutely critical evidence for all the reasons why. And there's nothing better than somebody saying, I was there, right? I saw what happened. And that person, it's a powerful statement in court and prosecutors law that usually, as long as a credible witness, pretty much wants to say that. So how does this happen? So the eyewitness identification, this is how it gets in the court. So the first thing that happens is something known as a still. Right? That's what we just talked about, where Mrs. Lee was down the, in the parking lot, the other side of the parking lot, police officers canvassed them near where the crime happened. And just so happened to find somebody that kind of was close to the description given by the bank teller. We put her in the car, brought her back to the bank teller, put her up with the multiple choice test. Put her in front of the witness and say, is this the person who did it? And she said, that's the person who did it. She said, no, it wasn't. She said it wasn't. So now the police officers have probable cause for making an arrest. Okay, so that's step one in eyewitness identification. The second thing that will go to is photo array. This happens after the person's been arrested and is being processed, right? Again, they'll bring the witness, the victim, usually to the police station and ask them to do another identification, where they'll put the picture of the individual in a photo with a number of individuals that look kind of like the particular person, and then ask them the person to again identify the person who did the crime. So, in this particular case, remember what this really looked like? Oh, which one? You're the eyewitness in this particular case. Good. How many people think number one? Number two? Number three? Four? Number five? One? So again, a photo array is a multiple choice test. In this particular case, there's no answer. She's not on. Like the picture's not there. Usually, right, when you take a test, and I give you 4 answers, you assume that there's one of the answers has to be right. Same thing in a photo array. You assume, right, that you've got to choose one for you the full map, whether you want. All right, photo array, and then the last part, two last parts, is of course the lineup, right? We line up, it's the same thing, where the individual Mrs. Lee would be put into actually 5 people and put into a lineup of usually 6 people that they use, and then again, behind a window usually, they'll say, "Can you take out the rock?" So just the lineup. Obviously, number 3 is the phase. That's essentially what you do. 6 people in the lineup, putting your potential suspect, and see whether and how the victim is. The last thing that happens, right, is the need court identification. So when Mr. Junction is put on the stand, he gives one of the eyewitnesses the Washburn case. The victims, who are also eyewitnesses, will be asking for, do you see the defendant in court? And then we'll look at how point is the individual sitting there. Think about this process. This is a process that biases towards conviction. Because from the very beginning, right, no matter how sure you were of like the very first step in the process, who did it, you're to show this person, all of a sudden that person gets turned down. Right? And then you're given a photo array, and then reaffirm what you think that person looked like. And then you do a lineup, and it's the same thing. So you're getting confirmation time and time again. By the time you get the court, again, I know that. The problem is getting at the truth. Getting at the truth is I don't really tough. You're 20 years old, second day on the job. Right? How observant are you going to be to get a gun help with they give you like most people. He was looking at it. Not paying attention to the features of the situation. He's doing a good job. So what research tells us is that eyewitness identification, the vagaries of eyewitness identification are well-known and in the law, like the mistaken identification is probably the number one reason why people who are later found because of eyewitness identification. Here's, one of those cases where this individual would you be able to, like, people look relatively close, the 3 individuals look relatively close as potential suspects. So if they were all in a lineup, would you make the difference? On the left, there's a guy by the name of Lawrence Benson who was arrested for several based on identification. The victim testified as well, took him out of the lineup, took him out of the photo array, that he did it, he was charged with 4 rapes because of it. Again, this is Moreno, who was also arrested for a series of robberies based on eyewitness identification. Again, the victim testified that he did it. He was arrested and charged with a number of lineups. Both men were picked out of the lineup each time. Mr. Benson here, again, was clear of the rape when the individual defendant admitted to the rape, and such the charges were dropped over for Mr. Benson. And so he was convicted of the rape, and to get a reduction in sentence, he later confessed to the robbery. So this is but 2 other individuals, long charge based on eyewitness testimony. why we're so bad. Right? And why I think in general, what research does is talk about two things: how we do it, how the system does, how we do identification. Part of the problem. The other part of the problem, I'll talk a little bit about these. The system variables are just how the system, how I are actually processed. Right? Look, number one, if you've been victimized, or if you're a witness, you want to help the police, you want serious crime to happen, you have that, right? And so you feel like you want to be able to be helpful, because you natural tendency to be able to do that, right? But also, what police officers do, in terms of helping you, they'll help you along the way. Okay, before they sit down with the lineup, the number of people in line, okay, we have the individual who has been suspected of committing this horrible crime, right? So already you're biased. You're already thinking that of the 5 people, of the 4 people, how many people are in that line that you have to have the right answer. And so you're going to pick the right answer. You have to pick the right answer. And then how they instruct, you know. So the police are trying to push you for individual, person, individual that so all those things, again, get you to where they want you to get to. Probably the more important variable is, most of you, right, it's early in the morning. A lot of you are really tired. A lot of you have your heads down. You're not paying attention. You're paying attention to your phone. You're looking at something else. Something happens fast. Some of you may have thought exactly what happened. More than likely, somebody's looking at their phone. So that is very difficult to distract. You imagine, think about lighting and lighting conditions. The lights are on today, darker than usual. I mean, lighter than usual. It's not. And think about it, 2 o'clock in the morning. Was there lights? How were the lights? Were all the lights, do you wear glasses? Were you wearing glasses? Were you drinking? How much were you drinking? All those things impact how we see things and whether or not we see things. All of these variables, lighting, conditions, stress, what you've been doing, what pressure you're feeling, how you're paying attention, all of these things. When we talk about conditions, whether or not, how much sleep you got last night, how much you did pay attention, and of course also, we all have a sense of bias in how we see what we do characteristics. This is an old experiment, a psychological experiment, experiment. And so, you're given that much, right? That's it. And you say, okay, one of the people on that train was totally nice, right? When this was it's really difficult. It's much better doing the actual from my actual. But this is actually a nice particularly pain. And so what they're trying to look at is you put the bias. The bias is that we make about who's like. You can see, look at this. All the people are potential witnesses in this particular case, right? So the woman here is kind of looking forward. She's not paying attention. She's not paying attention. This individual is speaking. At least looking at the altercation that is occurring, right? Holding baby, right? This is actually a potential fight. All those sorts of things, the important point is that they all affect what we see. Even what the experiment showed in this particular case is that the white individual that was holding the knife and was aggressive in this particular case, when people looked at it in the laboratory setting, they flipped it, right? They flipped it and put the knife in the black man. Again, that shows all the things in terms of our biases, how we see the world, our expectations about who's likely to be not, who's going to impact what we see and how we see particular events. We just that's not really good, that being a jury. None of them. Unless they're trained, to investigate. Question about witness identification. Couple more pieces of evidence that you don't care about. Circumstantial evidence. Circumstantial evidence is that evidence that requires interpretation. Right? It requires that there is a reasonable conclusion based on what the evidence is. You have to make an inference. Right? You're really giving direct testimony that you saw what happened. Right? So with circumstantial evidence, indirect evidence. Right? That you're in a hallway and an individual walks out of an apartment. You see that individual walk out of the apartment, right? And then the body is found, right? You didn't see what happened. You didn't see how much time was occurred. But you did see this particular individual. You might be using that as evidence. Simply so that this is the last person that left that particular apartment, but the body was found, and the call was this particular individual only provides the consent, and you see what happened. So you have to infer that this person committed the crime. That was how they got found. It's not as powerful as you want direct testimony by an eyewitness, but it's so important because it puts you at the hearsay, which again can't be allowable, of course, in different special circumstances. But it's not based on something, it's not based on your personal knowledge, but you testify to something you've heard. You have no direct knowledge. Again, there are pretty significant limitations on hearsay evidence and whether or not hearsay evidence is being recorded. Because, again, you have the right to cross-examine, you have the right to question your authority. So if the person who said it saw it, right, and the person that just heard it from that person isn't very good. So there are some exceptions, and then hearsay will be allowed. Sometimes it's just a contextual, in some of the testimony, when there's abuse involved, there's very difficult cases, most cases, testify in court, but some cases, particularly so. But you can see here, the courts are really struggling with it or not. You have the right to confront witnesses, you have the right to ask questions of witnesses, so as a 6-year-old, to ask questions, testify, people that are abused. There's still a right to question that particular 6-year-old that they're in fact telling the truth. How they do it. So if in one case, Chloe was style was physical news or corporate news that used the shield to child violate the competition clause, and this is probably the most common way that Chloe testified is through closed circuit television. So they don't have to be in the courtroom with person who that abused them, but they still have to testify. right, questions about evidence? Then the prosecution starts, presents all their evidence, they, close their case. The defense can either now, at this particular point in time, give their opening statement, or they'll also make a motion to withdraw the case, saying, you don't have enough evidence to move through, you made the limited, evidence or requirements, judges say, yes, they did, if you found, you put in the defense presents it. So the defense prosecution presents the witness, the defense prosecution presents the witness, the defense prosecution. Prosecution reads that. Once they're done, once they, are finished with their case, the defense presents the witness, prosecution, always the prosecution. Once both the defense and prosecution present all their evidence, we have closing statements. You can see that with this, where the opening statements, remember the prosecution starts the whole trial process. The prosecution presents their opening statement first, when the defense candidates their opening statement at the very beginning stage. At the end, on the other side of this, we have closing statements. Defense goes first in terms of saying their closing statement, and the prosecution actually gets the last word. So the jury gets asked to deliberate, prosecution then gets their closing statement. After closing statement, the judge will instruct the jury. It's really important to know that jury instructions are at the end of the trial process, not at the beginning. The only thing that happens with the jury is the selection of the jury at the beginning. The jury instructions is from the judge saying, look, this is what your job is. All right? You're asked to prove these 4 offenses. You hear the law, right? You're asked to only listen to the evidence that was presented here. You're not supposed to talk about the case outside of court. All these sorts of things, you have to find guilty, not a reasonable doubt what that means. You have to select a foreperson who's in charge of directing the and then the jury deliberates. There's really no timeline. The jury can deliberate for 6 months. And if they can't reach the verdict, they'll ask how the judge can't reach the verdict for the driver. Rebuttals of witnesses. So it usually happens with any of those steps. So if you go prosecution, defense prosecution go back, right? And then they can keep going back and forth for a period of time. And so at a verdict, right, we have a couple of options. 3 options. Jury can come back at. Number 1 is obviously that you get the verdict. So all 12 people, remember, it has to be unanimous for all 6, regardless of the size. Both choose the person guilty, and they go back to court. They can also find not guilty. Right? If they're found not guilty, the case is over and it's over forever. The prosecution never gets to go back at the guilty, not guilty. The third option is you can't make it. You come back to 100. 10 people think they're guilty, 2 people think they're not. Not all 12 have to. So, and then they fight it out. They keep talking about it. They keep arguing about it. They keep on going, asking the case to be read back to them. But there's 2 holdouts, and they're not going to finish it off. And they're either into that, and then they just get exhausted. And so the judge is saying, you can't reach the verdict, you can't reach the verdict, try. They don't want the case to go away, but if they can't reach the verdict, it's a hung jury. That means all the charges are dismissed, but the prosecutor can go back and recharge the person and start this whole process again. Start the whole court process over again. Go back to grand jury hearings, go back to arraignment, go back to motion hearings, and have another trial. You can have actually multiple trials, 3, 4, 5 trials, if you just can't get the jury to get to the end. Questions about any of that? I only got 4 minutes, but there's four important minutes, so I don't have time to talk about this case. It's a fascinating case. If ever you have time, read about it. It's a Lindbergh baby kidnapping case. It's extraordinary for a number of reasons. You just really got kidnapping. As well as the whole program. So, I need to get to the case. And so, the Lindbergh case, the media was exactly how we expected it to be ridiculous. Charles Lindbergh, flew the Spirit of St. Louis over the Atlantic Ocean first to profit, do so. The single engine plane was a celebrity. A celebrity of Kardashian and so when his baby, his young baby, his 1-year-old baby, was kidnapped, of course, he was celebrated. And the media was haunted, and they ruined the crime scene with a particular case because they went to their house and trampled the ground of their home, destroying all the physical evidence, among other things. And then at the court hearing, they talk about camera people and reporters essentially hanging from the rafters to get any aspect of the case. So it really disrupted the case. We talked about Shepard versus Maxwell earlier in the semester. The pre-trial publicity case brings the amount of publicity and the protections that have to be put in place. Now, two cases. One case, there's a number of photos that we did from the Lindbergh baby trial that later were found to be unconstitutional. One of the critical cases is Texas versus Texas. 1965 said you're not allowed to have cameras in the court. You're not allowed to have that presence. You can have reporters and you can have news media in the court, but you can see what happens here. Television industry, like other institutions, has activities and limitations beyond which you cannot go with. That area is not extended to an American courtroom. So Texas versus Texas in 1965 says we don't want cameras in the courtroom. You think it biases the jury? You think it biases the public about the case? Reporters can be there, they can take notes, they can have sketch drawings or whatever, but we can't have cameras there. So this was the law until, I know we gotta go, but we gotta get this other case done. This camera versus Florida. This was the law until 1981. As you know, your camera is your third hand in terms of what you're able to do. You probably have literally thousands and thousands of photos. The disruptive nature of cameras has changed. In 1981, Chandler versus Florida, the court changed its mind. Said, you know what? The public has the right to know what happened in court. And you think a good way to do that is to allow cameras. And so, up until 1981, cameras were not allowed. And so this is Chandler versus Florida, where the Supreme Court ruled that essence is no longer state law. And the critical thing is states, individuals can broadcast both television, video cameras, as well as photographs. All right, review session tonight at 8. Otherwise, study hard. Let's see you on Thursday.